Subscribe to our channel and press the bell icon so that you never miss any video lesson from Rao's IAS Study Circle. Join the official Telegram channel of Rao's IAS Study Circle to stay updated and get all the materials on the Telegram. The link to the channel can be found in the description box. Hello and welcome to Daily News Simplified, an answer to what, why and how of newspaper reading from UPSC Civil Services examination point of view. Now today let us take up the important news which has appeared in the New Delhi edition of the Hindu newspaper dated 30th of August 2022. These are the list of the news for today's discussion and their timestamp has been provided in the YouTube description. Now let's take this news appearing on page number 6. It says curing the patriarchal mindset of Indian legal system. Inclusion of feminist jurisprudence in the law curriculum, that is dealing with various laws pertaining to women and children, and also sensitization of legal practitioners and judicial officers in India must be considered. So the author in this article has highlighted about a case of Kerala Sessions Court. So the Sessions Court of Kerala granted anticipatory bail to an accused who was charged with sexual harassment. And the court stated that the charge of sexual harassment will not be attracted when the complainant was dressed in sexually provocative dress. However, this particular decision of the Sessions Court was stayed by the Kerala High Court. And based on this understanding, the author in this article has highlighted about the prejudicial mindset of the judges. And here he has used a term referred as Freudian slip. Now, Freudian slip refers to an internal or subdued wish of an individual. And this internal or subdued wish of the person causes unintentional error, as this internal or subdued wish reveals subconscious feeling of a person. And in this regard, the subconscious feeling of the judge is with respect to the patriarchal mindset of the Indian society. Now the author says that such a patriarchal mindset impacts liberty, freedom of choice and also integrity of women, and hence affect both Article 19 and 21 of the Indian Constitution. And in this case, the judge can be accused of violation of Article 15 and also Article 14, which talks about discrimination on certain grounds, including the ground of gender, and also a general fundamental right against equality. And based on these understandings, the author suggests that the judgment of a court should not be based on these prejudicial mindset, but rather based on reason. So here the author starts by saying that a Sessions Court in Kerala, while granting anticipatory bail recently to an author and social activist in the state in a case of alleged sexual harassment, observed that the offence under section 354A of Indian Penal Code is not prima facie attracted. That is, it is not attracted if the complainant was dressed in sexually provocative dresses. Now here let us understand about anticipatory bail and also some of the important highlights of section 354A of Indian Penal Code, and then we'll further try to analyze other aspects of this particular article. Now here section 354 of IPC says assault or criminal force to women with intent to outrage her modesty. So this provision says that whoever assaults or uses criminal force to any woman intending to outrage her modesty shall be punished with imprisonment for a term which shall not be less than 1 year, but which may extend to 5 years and shall also be liable to fine. So the punishment can vary from 1 year to 5 years. Now section 354A of IPC says sexual harassment and punishment for sexual harassment. Here it highlights that a man committing any of the following acts shall be guilty of the offence of sexual harassment. These acts are physical contact and advances involving unwelcome and explicit sexual overtures, demand or request for sexual favors, showing pornography against the will of a woman, or making sexually colored remarks. So all these acts and activities will be considered as an offence of sexual harassment. Now here let's also understand about anticipatory bail, and it has been defined or provided under section 438 of Criminal Procedure Code. So it says that when any person has reason to believe that he may be arrested on an accusation of having committed a non-bailable offence, that is where bail has to be provided by the court. then he may apply to the High Court or Court of Sessions, that is Session Court, for a direction under this section, that is whether he will get bail or not. Now, some of the examples of non-bailable offences are murder, dowry debt, attempt to murder, voluntary causing grievous hurt, kidnapping, rape, etc. Now, there are certain circumstances in which anticipatory bail may be granted, and there are certain circumstances in which anticipatory bail may not be granted or refused. So, the grounds in which anticipatory bail can be granted are: first, when it suggests that there are ample grounds to assume that the applicant may be detained for unreasonable grounds. Next, the allegations were made with false intent or to cause the claimant to be injured or humiliated and arrested. Third, arguments against the claimant are ambiguous or very generic in nature. Next, the name of the accused is not mentioned in the first information report or FIR. Next, the applicant satisfies the court that he is from a respectable family, has deep roots in Indian society, and is not likely to abscond or avoid court's proceedings or hinder the investigation in any way. Now, anticipatory bail can also be granted to a person who is weak and his opponents are either very strong or there can be a case of political rivalry. Now, the next point is that when can anticipatory bail be refused? So, such a bail can be refused if the court believes that once warrant of arrest is issued against the person, then such person is likely to abscond. Next, the person applying for anticipatory bail has already been imprisoned for cognizable offense on conviction, that is for serious offenses. Next, where the applicant can influence the investigation to his advantage if he or she is released. And next, when the evidence produced suggests that the accused is guilty of crime or wrongdoings. So these are the grounds on which the court might not grant anticipatory bail. So it is the discretion of the court whether to grant anticipatory bail or whether to refuse anticipatory bail. So here in this particular instance, anticipatory bail was allowed, but on the pretext that the complainant was dressed in a sexually provocative dress. So based on these understandings, the author has suggested that any judgment, particularly those of sexual harassment, should be based on reason and not on patriarchal mindset of the judge. Further, the author says that terming a woman's dress as sexually provocative and making it a reason to give bail to the accused charged under sexual harassment violates legal and constitutional morality and also constitutional norms. Because if we go through the provisions of CRPC, such a reason does not exist. And it is because of these reasons the author suggests that the guidelines provided by the Supreme Court in the case of Aparna Bhatt versus State of Madhya Pradesh should be followed. So here the Supreme Court held that the use of reasoning or language which diminishes the offense and tend to trivialize the survivor, especially in gender violence cases, is specially to be avoided under all circumstances. So here we can say that the Sessions Court did not follow the guidelines provided under Aparna Bhatt versus State of Madhya Pradesh, especially for gender violence cases or cases for sexual harassment. So this judgment overall reflects prejudicial bias, and such prejudicial bias involving patriarchal mindset also tampers rule of law and affects administration of justice. Now, not only that, it also demoralizes the women in their fight for justice, particularly those women who do not have sound financial or emotional support from their family. Such prejudicial mindset promotes patriarchal attitude and also customs which suppresses women's thought and behavior, and this overall results in denial of justice for women. And because of these reasons, the author suggests that Freudian slip must be avoided, which unintentionally reveals a judge's subconscious feeling or mindset. Now the question remains as to how to address this particular issue of patriarchal mindset or a prejudicial mindset. Now here reference can also be made to the statement of former Chief Justice of India N.V. Ramana, where he stated that there is a need for greater representation of women not only in Indian judiciary but also in the Indian legal system. Now when he says Indian legal system, it also means that there should be more women in the Indian judicial services and also more women practicing law at different levels of Indian judiciary, such as at High Court, at Supreme Courts, at lower courts, and also in the Lok Adalats. Now, greater representation of women in Indian legal system becomes important as it will not only address the prevailing gender imbalance in the Indian legal system, but it will also address the issue of gender sensitization. So it says that it will improve gender sensitization of judicial orders, example addressing rights of women, especially in cases of heinous crimes, including cases of rape, sexual harassment, murder, and domestic violence. It will help to improve gender-specific infrastructure within court premises, for example, having separate toilets for women. It will ensure women empowerment in the judicial arena. It will encourage women to pursue law as a career choice. And overall, it will help to improve ratio of women law graduates and women judges in India. Now, the aspect of low women representation was also highlighted by Justice Indira Banerjee, where she stated that so far Supreme Court has had only 11 female judges, and of late 4 female judges have been appointed recently. So there is a need for greater female inclusion, not only at all levels of Indian judiciary, that is at lower judiciary and also at higher judiciary, but also among Indian advocates. And for this purpose, women need to be encouraged to pursue law as a career choice. Now further, there is also need to include feminist jurisprudence in Indian law colleges, as it will lead to greater awareness of students on important laws and landmark Supreme Court judgments, such as Supreme Court judgment on Sabrimala, to protect constitutional and legal rights and dignity of women. And overall, there is a need for sensitization of legal practitioners and judicial officers, including judges, about feminist jurisprudence. Now, the Stanford Encyclopedia of Philosophy says that feminist philosophy of law identifies the pervasive influence of patriarchy and masculinist norms on legal structures, and also demonstrates their effect on the material conditions of women and girls and those who may not conform to cisgender norms. Now, the term cisgender is opposite of transgender. Further, feminist jurisprudence also considered problems at intersection of sexuality and law and develops reforms to correct gender injustice, exploitation, or restriction. And feminist legal philosophy is an effort to examine and reformulate legal doctrines to overcome entrenched bias and enforced inequality of the past as it structures human concepts and institutions for the future. Thus, overall, inclusion of feminist jurisprudence in legal courses helps to address the inequality faced by women in the society. It helps to ensure gender justice in the society and also tries to improve the conditions of women because of the patriarchal mindset. Now, even in India, there have been progressive legislations in favor of women. And these progressive legislations have been incorporated through successive amendments. For example, Protection of Children from Sexual Offences Amendment Act 2019. Now, this amendment increases the severity of the punishment by including death penalty for aggravated sexual assault on children, and also provides stringent punishments for other crimes against minors, including girls. Further, the amendments proposed under the POXCO Act also provide for fines and imprisonment to curb child pornography in India. Now, another important legislation is the Medical Termination of Pregnancy Act 1971, as it allows for aborting of pregnancy based on the advice of doctors. And recently, the Medical Termination of Pregnancy Amendment Act 2020 has increased the upper limit for termination of pregnancy from 20 to 24 weeks in certain categories of women or in certain cases. And the amendment has also constituted medical board at state level. Further, the Assisted Reproductive Technology Regulation Act 2021 regulates assisted reproductive technology services such as in vitro fertilization centers, sperm or egg banks, and also curb unethical practices such as sex selection. Further, the Surrogacy Regulation Act of 2021 allows only altruistic surrogacy and does not allow commercial surrogacy. So, the Surrogacy Regulation Act allows altruistic surrogacy, which involves no monetary compensation to surrogate mother other than the medical expenses and insurance covered during pregnancy, and also provides eligibility criteria for couples. Apart from this, it also constitutes Assisted Reproductive Technology and Surrogacy Board at national and state level. So these can be said to be some of the examples of progressive legislations in favor of women made in India. Thus, this article becomes very important both from our prelims and mains perspective, and in the mains, This topic gets covered under GS paper 1 with respect to Indian society and also under GS paper 2 with respect to legal and judicial reforms. Now let's take the next news for discussion appearing in the text and context section on page number 8. Now this news mentions about jurisprudence of bail. And here the news mentions that the Supreme Court has time and again reiterated or mentioned that bail is the rule and jail is the exception. The gist of the news says that jurisprudence of bail in post-independent India is anchored on the bedrock of Article 21 of the Indian Constitution, which states that liberty can be deprived only through the procedure established by law, which must be just, fair and reasonable. Hence, whatever the procedure law establishes, such procedure must also be just, fair and reasonable and should not be arbitrary. Now, this can also be said to be the incorporation of due process of law under the aspect of procedure established by law under Article 21. Now, the concept of due process of law was incorporated as a part of Article 21 in the famous Maneka Gandhi judgment. Now, in the previous article, we have already discussed about anticipatory bail. So, this news mentions about the jurisprudence or the legal system of bail in India. Now, the bail provisions for India are mainly governed through the Criminal Procedure Code. However, its impact can also be seen with respect to the constitutional provisions under Article 21 and 22 of the Indian Constitution. So, in this regard, let us understand certain basic aspects about granting of bail, both in the case of bailable and non-bailable offences. Now, we have seen that in case of non-bailable offences, bail has to be given by the court and hence it becomes the discretion of the court. That is, the court can either grant bail or refuse bail on certain conditions. Other than this, we shall also discuss about statutory bail and the concept of triple test. Now, in a sense, we have already seen triple test. As according to triple test formula, the Supreme Court, while granting bail or while considering that a person should be given bail, it considers these three important grounds. These grounds are whether the accused is at flight risk, that is, whether the accused will abscond. Second, possibility of tampering of evidence, that is, if the accused is released, then will he or she tampers evidence. And third, whether the accused, if released, will influence the witness in the case. So, based on the triple test formula with respect to provision of bail, the court ultimately decides whether to grant bail or not to grant bail. Now, before understanding about statutory bail, let's go through some of the important highlights with respect to bail. Now, there are two important conditions regarding bail. So, in bail, a person is released from the prison, and secondly, the person who is being released has to submit certain surety. So, it says that bail in law means procurement of release from prison of a person who is awaiting trial or an appeal. So, the person who is released is awaiting a trial, that is, a trial is going on. Further, the person shall be released on bail by the deposit of security to ensure his submission at the required time to legal authority. So, there are certain conditions attached to release of a person on bail. First of all, he has to submit certain monetary value with respect to surety, and also he has to ensure his presence before legal authorities. So, it says that the monetary value of the security, known as bail, or more accurately the bail bond, is set by the court having jurisdiction over the prisoner. So, this amount of bail which is to be submitted is decided by the court. It then says the security may be cash, it may be papers giving title to the property, or bond of private persons of means or of a professional bondsman or bonding company. Now, failure of the person released on bail to surrender himself or herself at the appointed time results in forfeiture of the security. It further says that courts have greater discretion to grant or deny bail in the case of persons under criminal arrest. So, overall, granting bail is ultimately the discretion of the court. Thus, this topic of bail and fundamental and other legal rights surrounding the conditions of bail becomes an important part of your prelims examination. Now, let's look into this question asked in the prelims of 2021 based on the concept of judicial and police custody. So, this question says that with reference to India, consider the following statements. First, judicial custody means an accused is in the custody of the concerned magistrate and such accused is locked up in the police station and not in jail. And second, during the judicial custody, the police officer in charge of the case is not allowed to interrogate the subject without the approval of the court. So to answer this question, you not only need to be aware about the constitutional provisions with respect to criminal justice system, particularly Article 20, 21 and 22, but also certain other legal aspects pertaining to arrest and bail conditions. And because of this particular question asked in 2021 UPSC prelims examination, this particular article on jurisprudence of bail becomes very important. And in the prelims, this topic gets covered under rights issues, and in the mains, this topic gets covered under GS paper 2, particularly with respect to fundamental and other legal rights. Now here let us first understand the correlation between Article 22 of the Indian Constitution and the steps taken by the police after registration of FIR. So Article 22 says that protection against arrest and detention in certain cases. So it says that no person who is arrested shall be detained in custody without being informed. So when the police arrests a person, then such person must be informed about their grounds of arrest. It further says that such person shall not be denied the right to consult and to be defended by a legal practitioner of their choice. So such person also have a right to be represented by the choice of their lawyers. It further says that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours. So when a person is arrested based on an FIR, that is first information report, then this person who is arrested is placed under police custody. So it means that a person is arrested and kept in the police station or under the police custody. And then within 24 hours, he or she has to be presented before a magistrate. This is according to Article 22, Clause 2 of the Indian Constitution. However, these provisions of Article 22, Clause 1 and 22, Clause 2 shall not apply to any person who is an enemy alien at that point of time, or to any person who is arrested or detained under any law providing for preventive detention. So these provisions mentioned under Article 22 Clause 1 and 22 Clause 2 shall not be applied to any person who is arrested under any preventive detention law such as UAPA or Unlawful Activities and Prevention Act. So when the person is produced before the magistrate, then in such instances, the court has three options. The court can either release the accused on bail. Next, the court can send the accused to police custody for a maximum period of 15 days. And the third option is that the court sends the person to judicial custody for either a period of 60 days or for a period of 90 days. Now this will depend on the crime for which the accused is imprisoned. So the provision of Criminal Procedure Code says that under Section 167, magistrate can either allow for police custody or judicial custody. Now magistrate may allow for further period of police custody of 15 days. However, the accused can also be sent to judicial custody for a period of 90 or 60 days. Now, when is a person sent for judicial custody of 90 days? When the crime entails a punishment of death, life imprisonment, or a period of imprisonment exceeding 10 years and 60 days. And for all other crimes, the accused is sent to judicial custody for 60 days. So basically, sending to judicial custody of an accused means transferring the person from police station to jail. Now, other than this, the police continues with the investigation and after a certain period completes its investigation and submits the investigation report, which is also known as or referred as charge sheet. Now here suppose the accused was sent to judicial custody for 60 days. And even after completion of 60 days, the police has yet not submitted the investigation report or filed the charge sheet. So in such situation, once this mandatory period of 60 days is completed, then such accused must be mandatory or according to law released on bail. Now this is referred as statutory bail. So section 167 clause 2 of CRPC further says that if at the end of the period of 60 or 90 days of judicial custody, if the investigation is not completed by the police, the court shall release the person if he fulfill bail conditions, and this is referred as statutory bail. Thus, a magistrate according to law or a statute, that is Section 167 of Criminal Procedure Code, cannot authorize a person's judicial remand beyond the period of 60 or 90-day limit. This is what is known as statutory bail. And the stipulated period within which the charge sheet has to be filed begins from the day accused is remanded for the first time, and it includes days undergone in both police custody and judicial custody, but shall not include those days spent in house arrest. So coming back to this question asked in the prelims of 2021, the first statement becomes incorrect, as it says that judicial custody means an accused is in the custody of the concerned magistrate and such accused is locked up in police station and not in jail. So it is incorrect, as the person is locked in jail. Second, during judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Yes, this is correct. The question here was which of the statements given above are correct. So of course the correct answer becomes B, that is 2 only. So after understanding the aspect of statutory bail and also correlation of bail conditions with Article 22, let us also understand about this general concept of presumption of innocence and the fact that bail is generally the rule and jail is an exception. Now the entire criminal jurisprudence is based on this fact that the accused shall not be considered guilty unless he is proven. So it says that presumption of innocence and the duty of the prosecution, that is the police, to prove the guilt of the person accused of an offence is the golden thread in criminal law jurisprudence. However, this golden thread of presumption of innocence is at times reversed, generally in the cases of preventive detention law. And according to presumption of innocence, every individual charged with a crime has a right to be presumed innocent until proven guilty. And the guideline that bail be the general rule and jail be an exception is the logical and consistent adaptation of principle of presumption of innocence to the pre-trial stage. Further, this concept of presumption of innocence is also enshrined under Universal Declaration of Human Rights, under European Convention on Human Rights, under Charter of Fundamental Rights of the European Union, and also under Nelson Mandela Rules, which is the United Nations Standard Minimum Rules for the treatment of prisoners. So these are some of the international principles which also supports the idea or principle of presumption of innocence. Further, the Supreme Court in the case of Sitharam Satlingappa versus State of Maharashtra had held that presumption of innocence would be effective by favoring bail. Hence, bail is generally considered as the rule and jail as an exception. And this legal principle that bail is generally the rule and jail is an exception was also approved by the Supreme Court in a landmark judgment of State of Rajasthan versus Balchand. Now the Supreme Court, while granting bail to the accused, held that bail should not be granted or rejected in a mechanical manner as it concerns the liberty of a person. Now here reference was also made to Article 21 of the Indian Constitution. Now in this judgment, this particular doctrine was laid down by Justice V. Krishna Iyer, who based it on the fundamental rights guaranteed by the Constitution of India, namely right to life and personal liberty. Hence the primary purpose of bail is to ensure that the accused is released and the accused also comply with the investigation and subsequent presence at the trial if they are released after arrest. And the court also stated that refusal to grant bail deprives individuals of liberty by confining them in jails without trial and conviction. So these are some of the highlights of Supreme Court judgment in State of Rajasthan versus Balchand. Now generally bail is the rule, but at times it gets difficult to get bail, especially for the poor and for marginalized or vulnerable sections. So it says that it becomes difficult to arrange money for bail bond, especially by the vulnerable and marginalized sections. It further says that the system of bail typically requires sureties to furnish a bond for some property valued at the amount determined by concerned judge. So it is difficult to arrange property papers, especially for people from the marginalized community. Now another problem becomes the bail amount, which in subordinate court is a minimum of 10,000 even for petty offences, and this further increases to 30,000 or even more in high courts and Supreme Court, and obtaining these amounts becomes difficult. Now an example highlighted here is that a 14-year-old minor surety for 4 cases of theft and housebreaking was set at rupees 2 lakh by the Sessions Court in Bhopal. And failure to provide bail bond or surety also increases cases of under trials. So it says that this can be said to be a form of injustice, that is providing 2 lakh rupees as surety when majority of citizens are landless with meager incomes. So without monetary asset, it becomes difficult for sizable population to arrange the bail amount for release, and hence greater number of accused ends up as under trials. So it says that those without assets, even when granted bail, end up languishing in jails or incur heavy debt which they have to repay back to ensure their freedom. So even getting out on bail becomes a liability. Further, grant of bail on personal bond without sureties, that is release on one's own guarantee without any monetary amounts, although permissible in law, is very rare. Thus it becomes difficult to arrange such large amount of money to obtain bail. And it is in this backdrop, the gist of the article says that prolonged detention of an accused pending trial may convert the process itself into a punishment, rendering a finding of acquittal practically useless as the accused would have suffered much of the punishment by then. And this is why grant of bail is fundamentally important. Thus this article on jurisprudence of bail becomes very important both from our prelims and mains point of view. Now let's take up the next news from the archive section appearing on page number 7. And it mentions about merchants' demand with respect to the Indian Merchants' Chamber and Bureau. Now this archive section presents news which was published 100 years ago. So this news is with respect to 30th of August 1922. So the Indian Merchants' Chamber and Bureau becomes important from our prelims perspective, particularly modern history. Now this particular institution, namely the Indian Merchants' Chamber and Bureau, was founded on 7 September 1907 by few Indian merchants who came together to establish a Swadeshi institution to fight for the rights of Swadeshi businesses. And this institution is headquartered in Mumbai. Another important fact is that the foundation stone of the Chambers building in Churchgate at Mumbai was laid by India's first Home Minister, Shri Sardar Vallabhbhai Patel. And the chamber exclusively served the interest of Indian business community and also took part in several key political movements prior to independence. And based on Indian Merchants' Chamber and Bureau's contribution to nation building, Mahatma Gandhi accepted the honorary membership in 1931, and this is the only chamber which has this distinction. Further, after independence, the Indian Merchants' Chamber has also played significant role in consolidating Indian business interest and making the Indian economy self-reliant. And at its 100th year, a postal stamp was issued by the Government of India recognizing the services of the Chamber. Now presently, the Chamber state-of-the-art International ADR Center or Alternate Dispute Resolution Center offers institutional arbitration of disputes in international standard facilities and established rules and panel of arbitrators. So in this news, you need to know certain facts with respect to Indian Merchants' Chamber and Bureau, as it was founded in 1907 by few Indian merchants to establish a Swadeshi institution to fight for the rights of Swadeshi businesses. It is headquartered in Mumbai. And considering the Chamber's contribution in nation building, Mahatma Gandhi accepted the honorary membership in 1931. Now based on our discussion, this becomes your first practice question for the day. So the question is, with reference to the contributions of Indian business class in the freedom struggle, consider the following statements. First, Indian Merchants' Chamber was founded by Sardar Patel to bring the group into freedom struggle. Second, Mahatma Gandhi was the honorary member of Indian Merchants' Chamber. So the question is, which of the statements given above are correct? Options are A, 1 only, B, 2 only, C, both 1 and 2, and D, neither 1 nor 2. So I hope after our discussion, you will be able to attempt this particular question. With this, let's take up the next news for discussion. The next news to be taken up appears on page number 12, and this news is with respect to SEED scheme. Now SEED stands for Scheme for Economic Empowerment of Denotified, Nomadic and Semi-Nomadic Tribes. Now the news says that tribe categorization work delays benefits under the SEED schemes. And this particular scheme has 4 important components, namely that of educational empowerment, health insurance, livelihood support, and also housing. So this news says that Union Social Justice Ministry has received 402 applications under this particular scheme across the country for benefits under the scheme. However, none of the applications received so far on SEET's online portal has yet been approved by the government. Now, this is because the exercise to categorize these 1400 communities under Scheduled Caste, Scheduled Tribe, and OBC is yet not complete. And because of this, the scheme for economic empowerment of denotified, nomadic, and semi-nomadic tribes has yet not been approved by the government. So in this news, we need to know who are these denotified, nomadic, and semi-nomadic tribes, and important recommendations of different committees with respect to denotified, nomadic, and semi-nomadic tribes. So the denotified tribes, nomadic tribes, and semi-nomadic tribes are one of the most deprived and economically weaker section or community in India. Denotified tribes are communities that were notified as being born criminals during the British regime under a series of laws, starting with Criminal Tribes Act of 1871. Now, because these communities were denotified, hence they were also subjugated, and the subjugation affected their lives and livelihoods. So it says that these communities were subjugated, persecuted, and neglected, and the policies of the colonial government affected their lives and livelihood adversely. Now, the lack of state support for denotified tribes, nomadic tribes, and semi-nomadic tribes continued even after independence, as these communities have not benefited much from planned development over 7 decades, and they were also deprived of state support which were provided to scheduled caste and scheduled tribes. Now, another problem for these communities is alienation from mainstream, and this has led to forcible alienation from their traditional occupations and habitations, and they have remained hunter-gatherers and pastoral communities. And because of these problems, various committees were formed by the Government of India. So, based on the recommendation of Iyengar Committee report, the acts which notified these communities as born criminals were deleted, and these communities were accordingly denotified. Further, the Renke Commission estimated their population to be around 10.74 crores based on 2001 census. And in 2015, the Government of India constituted the National Commission for Denotified, Nomadic, and Semi-Nomadic Tribes under the chairmanship of Shri Bhiku Ramji Idate. Now, the purpose of the committee was to prepare state-wise list of caste belonging to denotified, nomadic, and semi-nomadic tribes, and the commission was also tasked to evaluate the progress of development of these communities in the states so that a systematic approach can be developed for the development of these communities. Now, major recommendations of Idate committee were to set up a permanent commission at the center for denotified, nomadic, and semi-nomadic communities. Now, so far, a permanent commission has yet not been established. Second, to set up a separate department or directorate for denotified and nomadic communities in states. Further, to define nomadic tribes and denotified tribes. Further, to bring uniformity in categorization of denotified tribes and nomadic tribes as scheduled caste, scheduled tribe, or OBCs. So these denotified tribes and nomadic tribes should be categorized clearly either as scheduled tribe, scheduled caste, or other backward class. Further, the commission suggested for issue of single caste certificate and also sub-quota for denotified, nomadic, and semi-nomadic tribe within the quota of scheduled caste, scheduled tribe, and OBCs. Further, the commission also suggested for a caste-based census in respect of denotified, nomadic tribe, and semi-nomadic tribe communities in 2021 census. Further, to create awareness among these communities for their inclusion in the mainstream society. The commission also stated that there was a need for sensitization of different government officials, law enforcement agencies, and also local bodies so that these communities do not get differential treatment and benefits of mainstream schemes reach to these communities. Further, the schemes which the government formulate for these communities should focus on their health, education, housing, traditional art, and traditional expertise. Further, the commission also stated that since the livelihood of these communities were largely dependent on the forest, hence there was a need to review the Indian Forest Act and also Wildlife Protection Act to give them their natural habitats. Now, despite the suggestions, certain issues and concerns of denotified, nomadic, and semi-nomadic tribes still exist. The first is that the permanent commission as suggested by Idate committee has not been constituted. So it says that the government felt that setting up a permanent commission would be in conflict with the mandate of existing commission for scheduled caste, scheduled tribe, and other backward class. So instead, the government set up development boards under the Society Registration Act of 1860 under the aegis of Ministry of Social Justice and Empowerment for the purpose of implementing welfare programs. Now the second issue and concern is lack of constitutional support. So it says that these tribes somehow escaped the attention of our constitution makers and hence got deprived out of constitutional support system, unlike the scheduled caste and scheduled tribe. Further, there was no categorization of these communities into scheduled caste, scheduled tribe and other backward class. And there are also other denotified tribes or communities who are not covered under any of the reserved categories. Now another concern is that no money was spent in the year 2021-22 under the Scheme for Economic Empowerment of Denotified Communities, and budgetary allocation has been reduced to Rs 28 crore for 2022-23 as against the budgetary allocation of Rs 50 crores for 2021-22. So there has been reduction in budgetary allocation for the economic empowerment of these communities. Now another concern is that these communities are vulnerable and wrongly stigmatized. So it says that historically nomadic tribes and denotified tribes never had access to private land or home ownership. And even the National Commission to Review the Working of the Constitution in 2002 held that DNTs have been wrongly stigmatized as crime prone and subjected to high-handed treatment and have also been exploited by the representatives of law and order and in general by the society. Further, there have been issues with the functioning of the Development and Welfare Board for denotified, nomadic and semi-nomadic communities. Further, there have been inconsistencies observed while classifying these communities as scheduled caste, scheduled tribe or OBC. One of the examples highlighted in the news is that some communities such as Banjaras were under the scheduled caste list in Delhi, whereas in Rajasthan there have been categorized as scheduled tribe and has been categorized as other backward class in Uttar Pradesh. So this is also delaying the classification of these communities as scheduled caste, scheduled tribe or OBC. Thus these differences is making the classification bit more difficult. It further says that classification is important for the success of the seed program. So according to government officials, the categorization of DNTs, NTs and semi-nomadic tribes is essential for the implementation of seed program because there is no schedule in the constitution providing for their reservation. So these are some of the issues and concerns with respect to denotified, nomadic and semi-nomadic tribes. Thus this news becomes important both from the prelims and mains perspective. In the prelims gets covered under welfare schemes for the vulnerable section and in the mains gets covered under the governance section of GS paper 2. With this, let's take up the question for the day. Now based on our discussion, this becomes your practice question for the day. The question is Scheme for Economic Empowerment of DNTs or SEED has which of the following component? Options are first, educational empowerment, second, health insurance, third, livelihood support, and fourth, electricity and drinking water. So the question is select the correct answer using the code given below. Options are A, 2, 3 and 4 only, B, 1, 2 and 4 only, C, 1, 2 and 3 only, and D, 1, 2, 3 and 4. Now coming to the answer of yesterday, the question was which of the following provisions would be covered under the corrupt practices of section 123 of RPA. Options were debarring candidate for money laundering, second, asking for votes on basis of caste and community, third, booth capturing, and fourth, promoting sati system. And this the correct answer is B, that is 2, 3 and 4 only. With this we come to an end to today's discussion. Thank you for watching DNS.